first round, my lord, if my lords will please recall, my lord, this is that matter where 3 years law practice with 70% marks are required. My lord also gave protection to certain petitioners, my lord. That was later on because the petitioners didn't qualify. So the petition was dismissed, my lord. This is not by those petitioners. My lord, will please come to Annexure P4, page 250.
Tell us what is the point that you are trying to extend.
Yes, the point, my lords, is a neat point, my lords. My lords, in All India Judges Case 2002, held that 3 years practice cannot be laid down as a criteria for appearing in the civil judges examination, entry level. My lords also observed within paragraph 40 clearly that if any deviation from these directions has to happen, then it can happen by way of appropriating, instituting appropriate proceeding before this court only, and all the high courts and state governments are bound by. Now what happened, my lord? Without instituting any such application, my lord, the High Court of the state of Madhya Pradesh introduced this 3 years requirement of practice, my lords, as one of the preconditions for appearing in the examination, contrary to my lord's direction in the AIJ case.
Don't be so yes. sanguine about that suggestion of yours.
I am just. And alternatively, my lords, the requirement that was fixed was that either 3 years or 70% marks in the aggregate of 5 years or 3 years of law in the first attempt without ATKT. So I should not be failing in any of the law and non-law, even viva voce subject.
Yes.
Now, my lords, I have, for the purposes of today, my lord, though multiple arguments were made, there were multiple issues raised before the High Court. For today, my lord, I have 4 submissions, on which, my lords, I'll press, my lord. The first is, my lords, that obviously the second AIJ case, my lords, I'll just refer to that para 30 to 40. That the mandamus was issued by this court, my lords. It was binding on all the courts and the state government, and that mandamus could not have been overreached or bypassed by the state government or the High Court on the administrative side. That's one argument. The breach of mandamus makes the rule unalitimate. That's first submission. The second submission is, my lords, that the rule of from 2003 was amended in the case of Madhya Pradesh, 2003 to 2023. It is 2004 to 23. For almost 19 years, my lords, the rule contained prescription of fresh law graduates were eligible, my lords. 23 June, my lords, it was amended, my lords. So, my lords, what happens is, candidates who cleared law, 3-year, 5-year law course, lesser than 70% or more than 70% with ATKT or including the period during COVID, my lords, they were either had flunked one of the subjects, my lords, or were less than 70%. They were eligible from 2004 to 2022. Candidates who had prepared. 2023 were 19 years. So, my lord, the rule applies retroactively to disqualify all such hundreds and thousands of candidates, my lord, forever to participate in the examination. And, my lords, I refer to that. The High Court has also taken note.
Don't take too much trouble.
I have a request, my lord.
We are not going to entertain it. Yes. It took some years of learning out of the experience, and that is why these rules are incorporated. So we are not going to entertain it. Heard Mr. Siddhartha R. Gupta, Learned Counsel appearing for the petitioner. The Learned Counsel has made elaborate argument to challenge the impugned judgment of the division bench, upholding the validity of the rule. What is the full name of the rule?
Well, this is Rule 7, titled as Eligibility.
The eligibility rule 7.
MP Judicial Service Recruitment and Extension of Service Rule.
That's mentioned in the
Service Recruitment, etc.
7G to be precise.
7G. The justification given by the High Court to uphold the validity of rule have been taken into account. Stop. No infirmity. We see no reason to interfere with the same view. Stop. The SLP is accordingly dismissed.
May I just make one request?
Yes.
At least for this examination, almost 1,000 students appeared and they are qualified the mains, including the petitioner.
They can certainly appear after attain the qualification.
They can't. That is what my case is. Please appreciate, Malad. They can't now. They can't do the LLB. They can't do the LLB now. That is a difficulty. And
this is recruitment.
Yes, Malad. They can't do LLB now.
What are you talking about?
Yes, Malad. I am ready.
No. What LLB?
Yes, Manoj. The
It is
eligibility,
not admission.
it is eligibility, Manoj.
It is not admission.
It is the
to
recruitment
eligibility.
examination.
Yes, recruitment.
Yes,
So
so
what
If they are not LLB, how are they qualified for becoming a civil
Yes,
judge?
what I am saying is, please appreciate. I need 70% marks in the first attempt, all 3 years of practice. Now, in
what is the basis of 70% in the first attempt
Yes.
and 3 years practice? What is the basis? Tell us.
Yes, Manoj. That is the difference.
No. What is the basis? This is to attract
Yes.
people who are good,
Yes.
who would be improving the judicial system.
Yes,
That's all.
I am great.
So that is the only thing.
I am just submitting. Manoj, just give me 30 seconds, Manoj. Perhaps I have not been able to convey myself. It relates to future of these hundreds of candidates. That
What their future is not doomed. Let us be very clear about that.
yes, what I am
Let them continue to practice for 3 years and then.
the petitioner cannot do. This petitioner cannot do.
Why he cannot do?
Yes, she cannot do.
Tell us very come to the point. Don't beat around the bush.
Because she is in a government service.
Yes.
She has to leave the till the time she is into government
Ajay,
service.
look at that.
Then we have, what part of your future? You are already in government
You
service.
have to leave that.
How your future is ruined?
Then if you choose to remain in the government service, you remain in the government service. You have to have the options. You can't be. That's why the expression you can't.
Yes.
What is the expression of cake?
Eat the cake.
Have my cake and eat it.
Exactly.
Yes.
Exactly. You put it in the right perspective. Yes. Dismiss.
This is what I was